This is HOA Karen Gets Denied. She brought a ruler and a grudge. Sharon was standing at the end of my driveway with an ice scraper held out like she was about to deliver a court verdict. "The fine meter is running and you are feeding it," she said, her voice sharp enough to crack the frozen air. She pointed at the sidewalk where a thin sheet of ice had formed near the curb. "Your driveway drainage created this hazard and I am writing you up for a winter safety violation." She had her clipboard out, the pages protected in a clear plastic sleeve, and she was already scribbling something down. I checked my watch. It was 5:15 on a Tuesday evening in February, and I had 3 hours before my remote shift started. The power had flickered twice that morning and my internet was already unstable. I could not afford another outage caused by HOA chaos spilling into my workday. I work as a postal carrier in Colorado Springs, and I hear all the neighborhood gossip before it even hits the group chat. I knew Sharon Campbell had been appointed compliance officer 3 months ago, and I knew she had been writing violations like she was getting paid per infraction. The Brookhaven Property Owners Association had given her a reflective vest and a mandate to patrol for winter violations, and she wore that vest like it was body armor. She had it on now, bright orange against the white parka, glowing in the porch light. "This is not my ice," I said. "The city plow came through this morning and shoved half a snowbank onto my apron. It melted during the day and refroze when the temperature dropped." She shook her head and tapped the clipboard. "You should have read the rules before you moved in, sweetheart." Section 12. Subsection 4. Property owners are responsible for all drainage and runoff that affects common areas, including sidewalks. You have 24 hours to remediate, or you are facing a $500 fine and a formal hearing. I felt my jaw tighten. The plow had dumped that berm at 9 in the morning. I had been on my route all day and only got home at 4. There was no way I could have cleared it before it refroze. I pulled out my phone and took a photo of the ice patch, then another of the snowbank still piled against my driveway apron. Sharon stepped closer and held up the ice scraper between us like a barrier. "Do not take photos of me without permission," she snapped. "I am documenting a violation in my official capacity." "I am documenting the plow damage in my capacity as the property owner," I said. I kept my voice level. "I am also documenting the timeline because you are claiming I created this hazard when it was caused by a city contractor this morning." She wrote something else on the clipboard and then looked up at me with a thin smile. "I am calling management and I am going to be dramatic about it," she said. "You can expect a certified letter by Friday. If you do not comply, we will escalate to collections and put a lien on your property." I watched her turn and walk back toward the street. A maintenance worker in a reflective vest was standing near the corner lamppost, watching silently. He had been clearing a storm drain when Sharon arrived, and he had not moved. I caught his eye, and he gave me a small nod. I figured he had seen the whole thing. I saved his position in my mental file and went inside. The house was cold. The thermostat was set to 68, but the furnace was struggling to keep up. I poured coffee and sat down at my desk. My shift started at 8, and I needed to stay online for 6 straight hours. If the power went out or the internet dropped, I would miss dispatch windows and lose pay. The HOA nonsense was already eating into my prep time. I opened my email and found a message from the Brookhaven Management Company timestamped 40 minutes earlier. It was a pre-violation notice with a PDF attachment. I opened it and saw a photo of my driveway taken at an angle that made the berm look twice as big. The timestamp said 4:15, which was 15 minutes before I even got home. I did not play my hand yet, and she thought that meant I had none. I had been a postal carrier for 6 years, and I knew how to track documentation. I also knew that Sharon had a habit of taking enforcement photos right after the plow came through and calling the resulting mess my pile. I opened a new folder on my desktop and labeled it Brookhaven Evidence. I dropped the email and both phone photos into it. Then I opened my browser and logged into the City Public Works portal. I pulled the plow route schedule for my street. The log showed a pass at 9:02 in the morning. I screenshotted it and added it to the folder. My phone buzzed. It was a text from my neighbor 2 doors down, a retired engineer named Paul who had been on the HOA board for 8 years before he quit last spring. He had warned me when I moved in that the board was getting more aggressive under the new president. The text said, "Saw Sharon at your place. She is targeting you. Be careful." I texted back and asked if he would be willing to talk. He replied immediately, "Come by tomorrow morning before your route." I checked my watch again. It was 6:30. I had 90 minutes before my shift. I made another pot of coffee and pulled up the Brookhaven bylaws on the association website. Section 12, subsection 4 did mention drainage responsibility, but it also included a clause about reasonable timelines and force majeure. A city plow dumping a berm outside of my control was textbook force majeure. I took screenshots of the relevant pages and added them to my folder. At 8 o'clock, I logged into my remote dispatch system and started my shift. The internet held steady for the first 2 hours, then stuttered twice around 10. I lost connection for 90 seconds and had to reconnect manually. The system flagged it as a disconnect and docked my availability score. I felt my blood pressure spike. If Sharon kept escalating, I was going to be stuck dealing with hearings and appeals during work hours, and that would torpedo my performance metrics. I needed this resolved fast. The next morning, I knocked on Paul's door at 7:15. He opened it holding a mug of tea and waved me inside. His living room was warm and cluttered with old board binders stacked on a side table. He saw me looking and shrugged. "I kept copies," he said. "I knew this day would come." He sat down, and I told him about Sharon's visit, the ice scraper threat, the timeline mismatch, and the pre-violation notice. He nodded the whole time like he was checking items off a list. "She is doing this on purpose," he said. The board adopted a new winter enforcement protocol in December. It is part of a push to increase revenue through fines. They are calling it proactive compliance, but it is just a shakedown. Sharon is the tip of the spear. He pulled one of the binders off the stack and opened it to a tab labeled Enforcement Policy. He flipped to a page with handwritten notes in the margins. "See this? The protocol says compliance officers can issue violations for any condition observed during patrol, even if the condition was caused by a third party. It also says property owners have 24 hours to remediate, regardless of when the condition occurred. It is deliberately punitive." "Can they enforce that?" I asked. "Probably not," Paul said. "But they are betting most people will not fight it. They will just pay the fine and move on. The ones who do fight usually give up after the first appeal because the process is designed to be exhausting." He closed the binder and looked at me. "You are going to need documentation, witnesses, and a willingness to go all the way to a formal hearing. If you do that, you have a good chance of winning. But Sharon is not going to back down. She has the board president's full support, and they have been targeting people who push back." I felt a weight settle in my chest. I was hosting a family gathering in 10 days. My brother and his wife were flying in from Kansas, and my parents were driving up from Pueblo. The last thing I needed was an HOA circus in the middle of it. But I also was not going to roll over and pay $500 for ice I did not create. I went to work and ran my route. It was a clear day, but the streets were still lined with dirty snowbanks, and the sidewalks were a patchwork of ice and salt. I delivered mail to 200 houses and heard 3 separate complaints about HOA winter violations. One homeowner had been cited for not clearing his roof vents. Another had been cited for parking a car on the street during a snow emergency that was never officially declared. The third had been cited for a seasonal porch flag that Sharon claimed violated winter decor guidelines. Everyone used the same phrase when they talked about her. "She is out of control." I got home at 4 and found another envelope taped to my door. It was a formal violation notice on Brookhaven letterhead. The violation ID was printed at the top, and the description was 3 paragraphs long. It repeated the drainage language from Sharon's clipboard and added a new clause about negligent maintenance. The fine was listed as $500, due within 14 days, with a late fee of $50 per week after that. At the bottom was a line that said disputes must be submitted in writing with supporting documentation in a format approved by the compliance officer. I read it twice and felt my stomach turn. She had added a format requirement that was not in the bylaws. It was a trap. If I submitted my evidence in the wrong format, she could reject it and escalate to collections without a hearing. I took photos of the notice and added them to my folder. Then I texted Paul. He replied with a single word: expected. If you are enjoying this HOA nightmare, hit that like button and subscribe for more stories where the rules come back to bite the enforcers. That evening, I sat down and wrote a response. I kept it short and formal. I stated the facts. The plow came through at 9:02 in the morning. I was on my route all day. The ice formed from meltwater caused by city equipment, and I had photographic evidence and public works logs to support my timeline. I cited the force majeure clause and requested a formal hearing. I saved it as a PDF and emailed it to the management company with a read receipt request. Then I printed 3 copies and put them in a folder. 2 days later, I got a reply. It was not from the management company. It was from Sharon directly, sent from her personal email address. The subject line said, RE, violation dispute, denied. The body was 2 sentences. Your submission does not meet the compliance format requirements. You have 12 days to pay the fine or we will proceed to collections. I forwarded the email to Paul and called him. He picked up on the second ring. She is freelancing, he said. She does not have the authority to deny your dispute. That has to go through the board or the management company. Forward this to the management company and CC the board president. Make them own it. I did exactly that. I sent a new email with the subject line Formal Dispute Appeal and Violation ID and attached my original response, Sharon's denial, and all my evidence files. I CC'd the board president, the management company, and Paul. I got an auto reply from the management company saying they would respond within 3 business days. 3 days later, I was shoveling my front walk when a flatbed tow truck pulled up to the curb. The driver got out and walked toward my driveway holding a clipboard. I stopped shoveling and met him at the street. He looked at the clipboard and then at my car parked in the driveway. Are you the owner of the blue sedan? He asked. I am, I said. Why? He showed me the clipboard. I have an authorization from the Brookhaven HOA to tow this vehicle for a safety violation. It says the car is parked in a manner that obstructs snow removal access. I felt my chest tighten. My car was parked completely on my own property, at least 6 feet back from the sidewalk. There was no obstruction. I pulled out my phone and took a photo of my car, then another of the tow truck. Who authorized this? I asked. The driver checked the clipboard again. Someone named Sharon Campbell. Compliance officer. I felt my jaw clench. She had escalated to a tow without any hearing, without any further notice, and based on a claim that was completely false. I called Paul immediately. He answered, and I explained the situation. He told me to put the driver on the phone. I handed over my phone and watched the driver listen, nod, and then hand it back to me. Paul's voice was tight. Tell him he is not touching that car. I am calling the management company right now. If he hooks it, it is an illegal tow and the HOA is liable. The driver held up his hands. Look, I am just doing what the work order says. If there is a dispute, you need to work it out with whoever hired me. I am not getting in the middle of an HOA fight. I asked him for a copy of the work order. He took a photo of his clipboard screen and texted it to me. The authorization was dated that morning and signed with Sharon's name. I thanked him and he left. I went inside and pulled up the work order on my phone. It included a claim that my car had been parked in the same spot for 72 hours in violation of emergency snow route rules. That was a complete fabrication. I had driven to work every single day. Paul called me back 10 minutes later. The management company is furious, he said. They did not authorize the tow. Sharon called the tow company directly and used her compliance officer title to make it sound official. The management company is sending her a cease and desist letter, and they are putting a hold on all enforcement actions until they can review her conduct. I felt a flicker of relief, but it did not last long. That evening, I got a text from another neighbor, a single mom named Angela who lived across the street. She said Sharon had been by her house that afternoon and told her she was compiling a list of properties with repeat violations. Angela had been cited twice in January for minor issues, a trash can left out past collection day and a holiday wreath still up in February. She said Sharon had hinted that repeat offenders would face accelerated enforcement and possible liens. I texted Paul and told him. He replied immediately. She is building a target list. This is not random. She is going after people she thinks will not fight back, and she is using intimidation to keep everyone quiet. I sat at my desk and stared at my evidence folder. I had the timeline, the photos, the plow logs, and now the illegal tow work order. But I still did not have the one thing that would shut this down permanently. I needed proof that Sharon was operating outside her authority and that the board knew about it. I needed the smoking gun. 2 days later, Paul forwarded me an email. The subject line said FW, board discussion, enforcement targets. The email chain was from an internal board thread that Paul had been copied on by mistake when someone hit reply all. It included a spreadsheet attachment labeled Q1 Priority Properties. I opened it and felt my blood run cold. My address was on the list, highlighted in yellow, with a note next to it that said high compliance resistance, escalate to lien if necessary. There were 11 other addresses on the list. I recognized 3 of them as people I had talked to on my route. Every single one had been cited multiple times in the past 2 months. The spreadsheet included columns for violation type, fine amount, payment status, and escalation action. Next to my name, it said pending collections referral authorized lien filing if payment not received by March 1. I forwarded the email to my personal account and saved the spreadsheet in 3 different places. Then I called Paul. He sounded grim. This is it, he said. This proves selective enforcement and coordination between Sharon and the board. If you take this to the city, they will have to investigate. If you take it to a lawyer, you can probably force a settlement. I asked him if he would testify at a hearing. There was a long pause. I am scared, he said. If I go on record, they will come after me next. But if you can get this in front of a neutral third party, I will back you up. I spent the next 2 hours researching my options. Colorado has a state statute that requires HOAs to follow fair enforcement procedures and prohibits retaliatory actions. If I could prove that Sharon and the board had targeted me based on a preconceived list, I could file a complaint with the Colorado Division of Real Estate and potentially force the board to mediation. But I needed to act fast. The March 1 deadline was 8 days away, and if they filed a lien, it would wreck my credit and make it nearly impossible to refinance or sell. The next morning, I went to the City Code Enforcement Office. It was a small office in a municipal building on the south side of town, staffed by 2 inspectors and a front desk clerk. I asked to speak to someone about HOA overreach and sidewalk drainage disputes. The clerk directed me to an inspector named Martinez, who handled residential complaints. I sat down in his office and laid out the whole story: the plow berm, Sharon's violation, the illegal tow attempt, and the leaked spreadsheet. Martinez listened without interrupting. When I finished, he leaned back in his chair and sighed. HOAs are a nightmare, he said. We get complaints every week, but our jurisdiction is limited. We can investigate code violations and verify compliance with city ordinances, but we cannot intervene in HOA internal enforcement unless there is a clear safety issue or a violation of state law. I pulled out my phone and showed him the spreadsheet. He studied it for a long moment, then looked up at me. This is selective enforcement, he said. If you can prove the HOA is targeting you based on a predetermined list and not based on actual violations, that is a civil rights issue under state law. You need to file a formal complaint with the Division of Real Estate and request mediation. He printed out a complaint form and handed it to me. You will also want to document every interaction with this compliance officer. If she shows up at your property again, record it. If she sends you emails, save them. If she makes threats, write them down with dates and times. I left the office with the complaint form and a list of attorney referrals. That evening, I filled out the form and attached every piece of evidence I had: photos, emails, the plow logs, the tow work order, and the leaked spreadsheet. I submitted it electronically and got a confirmation email saying the division would review it within 10 business days. 2 days later, Sharon showed up at my house again. It was 6:15 in the evening, and I was in the middle of my remote shift. I heard a knock at the door and checked the doorbell camera on my phone. It was Sharon, wearing her reflective vest and holding a flashlight even though the porch light was on. I muted my dispatch line and went to the door. I opened it and stayed in the doorway. "What do you need?" I asked. She held up a sheaf of papers. "This is your final notice before collections referral. You have 48 hours to pay the $500 fine plus a $100 administrative fee for the dispute appeal. If you do not pay, we will file a lien on your property and refer your account to a collections agency." I pulled out my phone and started recording. "I am recording this conversation," I said. "You are aware that I filed a formal dispute and that the management company put a hold on enforcement actions, correct?" Her face tightened. "The hold was lifted," she said. "The board reviewed your case and upheld the violation. You are out of options." I kept my voice calm. "Did the board hold a hearing?" She hesitated. "The board reviewed the file in executive session." "Was I notified of that session?" Another pause. "You were notified by email." "I did not receive any email," I said, and I checked my spam folder. "When was it sent?" She looked down at the papers. "It was sent this morning." "So you are claiming the board held a hearing this morning, notified me this morning, and you are now delivering a final notice tonight?" She did not answer. I kept recording. I said, "I have documentation showing that the board placed me on a target list and authorized escalation to a lien regardless of whether the violation was valid. I have also filed a formal complaint with the Colorado Division of Real Estate. If you proceed with a lien filing, I will add it to the complaint as evidence of retaliation." Her mouth opened and closed. She took a step back. "You cannot do that," she said. "I can, and I did," I said. "And I have a copy of the spreadsheet that shows my address highlighted with a note that says escalate to lien if necessary. That was dated 2 weeks before you even issued the violation." She turned and walked off the porch without another word. I watched her get into her car and drive away. Then I stopped the recording and saved it to my evidence folder. I went back inside and unmuted my dispatch line. My hands were shaking. The next morning, I got a call from the Brookhaven Management Company. It was the property manager, a woman named Jessica, who sounded exhausted. She told me the board had reviewed my complaint file and decided to place the violation on indefinite hold pending the Division of Real Estate investigation. She also told me that Sharon had been removed from active enforcement duties and would no longer be conducting patrols. I asked what that meant for the fine. She said the fine was being waived and the violation was being expunged from my account. She apologized for the confusion and said the board was reviewing its enforcement protocols. I thanked her and hung up. I texted Paul. He replied with a single word: progress. But I was not done. I wanted a formal settlement that included language preventing future retaliation and a written acknowledgement that the violation was invalid. I also wanted Sharon permanently banned from any enforcement role. I contacted one of the attorneys on the referral list and scheduled a consultation. His name was David Chen, and he specialized in HOA disputes. We met at his office 2 days later. I brought my entire evidence folder and walked him through the timeline. He took notes and nodded occasionally. When I finished, he leaned back and smiled. "You have a very strong case," he said. "The leaked spreadsheet is the key. It proves premeditation and selective enforcement. The illegal tow attempt is icing. The recorded threat is the cherry on top. If we take this to mediation, the HOA will settle. They cannot afford to have this go to a hearing where the spreadsheet becomes public record." He drafted a demand letter that afternoon. It requested full fee refunds for all disputed charges, a written apology, a no-contact directive prohibiting Sharon from any further interaction with me, a permanent ban on enforcement actions related to winter drainage for the remainder of the season, and an agreement that the HOA would adopt a formal app EELS process reviewed by a neutral third party. He also requested that Sharon be stripped of access to the portal admin tools and that the board implement mandatory training on selective enforcement and retaliation. The letter went out the next day by certified mail. 4 days later, I got a response from the management company requesting a mediation session. The session was scheduled for the following week at a neutral location, a conference room at a local business center. I arrived early with David. The board president, the property manager, and Sharon were already there. Sharon would not look at me. The board president looked like he had not slept in days. The mediator was a retired judge named Ellen Torres. She opened the session by reviewing the complaint file and the demand letter. Then she asked Sharon to respond. Sharon started to speak, but the board president cut her off. "We acknowledge that enforcement protocols were not followed," he said. "We are prepared to offer a settlement." David laid out our terms. The board president agreed to all of them except the portal access ban. He argued that Sharon needed access to file reports. David countered by pulling up the tow dispatch logs and call recordings I had obtained through a public records request. The logs showed that Sharon had called the tow company 3 times in one day, escalating her authority each time until the driver agreed to issue the work order. The recordings included Sharon saying, "I am calling management and I am going to be dramatic about it," followed by a separate call where she repeated the same line to the tow dispatcher. The mediator listened to the playback and turned to Sharon. "Did you authorize this tow without board approval?" Sharon hesitated. "I was acting in my capacity as compliance officer." The mediator shook her head. "That exceeds your authority under the bylaws." This recording demonstrates a pattern of retaliatory escalation. The board president closed his eyes. "We agree to the portal access ban," he said. David pressed further. "We also want written acknowledgement that the original violation was invalid and that the target list constitutes selective enforcement under state law." The board president looked at the property manager. She nodded. He sighed. Agreed. The settlement was finalized that afternoon. It included full fee refunds, a formal apology on Brookhaven letterhead, a no-contact directive with penalties for violations, a ban on retaliatory winter enforcement, mandatory board training, and Sharon's removal from all enforcement and administrative roles. The board also agreed to adopt a third-party appeals process and to submit quarterly compliance reports to the Division of Real Estate for the next 2 years. I walked out of that conference room with a signed settlement agreement and a check for $700 covering the original fine, the administrative fee, and my attorney consultation costs. David shook my hand and told me it was one of the cleanest wins he had seen in an HOA case. Paul texted me that evening. He said word had already spread through the neighborhood and 3 other homeowners were filing complaints based on the leaked spreadsheet. 2 weeks later, my family arrived for the gathering. My brother and his wife landed at the airport on Friday afternoon and my parents drove up Saturday morning. The weather was clear and cold, and the streets were lined with snowbanks that sparkled in the late winter sun. I grilled steaks on the back patio, and we ate inside by the fireplace. No one from the HOA showed up. No one left a notice on my door. No one called or emailed. It was quiet. On Sunday afternoon, my brother and I took a walk around the neighborhood. We passed Sharon's house, and I saw her in the driveway scraping ice off her windshield. She glanced up and saw me, then looked away and went back to scraping. I did not say anything. I just kept walking. That evening, after everyone had left, I sat down at my desk and pulled up the Brookhaven portal. The enforcement section had been restructured. Sharon's name was no longer listed under compliance officers. The new process required all violations to be reviewed by a third-party compliance consultant before any fines could be issued. The board had also posted a notice that the winter enforcement protocol had been suspended pending a full audit by the Division of Real Estate. I closed the laptop and checked my watch. My remote shift started in an hour. The internet was stable. The power had not flickered in 3 days. The house was warm. I poured a fresh cup of coffee and looked out the window at the snow-covered street. The porch lights were glowing in the blue-hour dusk, and the neighborhood was calm. For the first time in weeks, I felt like I could breathe. I hope this story was worth your time.